Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everybody.
Now, apologies for the lack of jingle. We had a slight technical error, but what's important is what we're saying. So we'll get straight on with that. Now, no sooner does LLG launch its members planning code, do we learn last week that the Supreme Court has granted permission to the claimant to appeal against the Court of Appeal in the matter of Spitalfields Historic Building Trust and the London Borough of Tower Hamlets and Old Truman Brewery. This, of course, concerns the lawfulness of standing orders, preventing planning committee members from voting on a planning application if they were not present when the application was previously considered by the committee. Shout out here to Landmark Chambers, who dropped this news into our channels with great speed. Another week then, and lots to talk about. Dennis, what's your first item?
Well, Helen, just before I get on to that, can I say that the Spitalfields case is on the slate for next week's Grapevine, so I'll have an item on that. But turning now to this week's first item. The Levelling Up and Regeneration Act 2023 contains some unusual provisions that can easily be overlooked, but they are important. They may prove highly significant in practice. Take Part 11 of the Act, for example, and the issue of the contractual control of land. That may have you guessing, so here's more. Part 11 of the Levelling Up and Regeneration Act looks to provide greater transparency on contractual control agreements in England and Wales. When government refer to contractual controls, they are referring to agreements such as option agreements that are used to control land short of outright ownership. And of course, all councils frequently use option agreements and development contracts with developers, which would fall within this classification. Now, the regulations which the government plans to deliver under the Act seek to create a data set comprising the what, where, who, and when of contractual control agreements that will promote transparency by providing a reliable and accessible source of information for communities, developers, and all other stakeholders. And bear in mind, these proposals relate to the whole of England and Wales. There's a new consultation out which seeks views on the government's plans to provide a more transparent picture of controls on land through the creation of a freely accessible data set. And of course, most local authorities will be involved in these contractual controls. Following the 2020 call for evidence and taking into account the responses government received, this new consultation clarifies the government's rationale for this measure and seeks the views of individuals, organisations and businesses' views on the time, cost and market impact implications of collecting and publishing information about these contractual control agreements. Government are also publishing draft regulations to invite views on whether the legal drafting is clear, precise and delivers the policy intent as set out in the consultation. The closing date for the consultation is the 20th of March, and more detail is in Bulletin 4. Helen.
Well, we would certainly be very pleased to hear from members who are submitting responses on this, so please do let us know and share anything you have put together with us. Now, the Equality and Human Rights Commission have produced guidance on religion or belief in the workplace, and this is an area that many employers struggle with, I think. And the Commission have helpfully also produced a toolkit to assist on handling religion or belief requests. So in this context, we're obviously concerned with the Equality Act 2010 and the Human Rights Act 1998. And I think whilst most people have a better understanding of direct discrimination, it's likely to be indirect discrimination, which forms a more grey area for decision makers, especially the objective justification element. So as well as the guidance and toolkit, there's a frequently asked questions section, which details several areas, most likely seeking clarification. And these are time off work for breaks during work hours and extended periods of leave, recruitment, specifically requests that might be made at an interview, food and dietary requirements, providing food and drink at work and issues around fasting, dress codes and religious symbols, objections or requests to change dress codes or the wearing of religious symbols, opting out of work duties, sort of around handling meat or alcohol or when delivering a service. And then the thorny issue of expressing personal views and beliefs at work, which includes discussions in the workplace and views that may or may not discriminate against or harass another group. It's a very helpful guide, and it also examines the issue of an employee whilst requesting adaptations on the basis of religion or belief would in consequence be discriminating themselves against others holding protected characteristics, and what this means for you as an employer. The other thing it includes is the issue of discussing religion or belief in the workplace and how this might balance against freedom of speech. Given the high profile cases which have happened in this area, it's certainly one to familiarise yourself with, and of course an absolute must for HR and all managers. Lawyers will no doubt learn something also, even if you don't work within employment law. Now, Dennis, I do a lot of work for charity, but I don't like to talk about it. Listeners of a certain age might get that reference. But in all seriousness, there are big changes ahead for the charity world, and they're coming into force this year, Dennis, I believe.
Indeed, they are, Helen. All local authorities, of course, are involved with charities in one way or another, and these new provisions are coming into force in 2024 as part of the Charities Act 2022. Here's the detail on this. Let's look first at the changes to governing documents. The Act is introducing a new statutory power that trusts and unincorporated associations will be able to use to make changes to their governing document. And these charities will need to have the Commission's authority to make certain what are termed regulated alterations. These changes include, first, how unincorporated charities must pass trustee resolutions with the new power. Second, that the Commission will apply the same legal test when deciding whether to give authority to charitable companies, CIOs and unincorporated charities when changing their charitable purposes. And third, a power for the Commission to give notice or to direct a charity to give notice of regulated alterations to a governing document. And finally, existing statutory powers for certain small charities to change their governing document will also be repealed. Next, there are new provisions on the selling, leasing, or otherwise disposing of charity land. New provisions relate to disposals by liquidators. These govern mortgages and changes that must be included in statements and certificates for both disposals and mortgages. Now, this is a complex area, and there's more detail in the link in the bulletin. Turning now to charity mergers. For certain mergers, new rules will allow most gifts to charities that merge to take effect as gifts to the charity they have merged with. The existing statutory process for certain small charity mergers will be repealed. Other provisions will provide for the Commission to have power to authorise a trustee to receive or retain a payment for work completed for the charity where the Commission decides it would be inexorable for a trustee not to be paid. Second, the Commission will be able to confirm defective or potentially defective trustee appointments. Now, there's much more detail on this in Bulletin 4 and on the Charity Commission website. Helen.
Thank you, Dennis. I could see that being relevant to anyone who might be advising councillors who sit on outside bodies, normally quite a complex and time-consuming area when looking at those. Now, in other news, the Office for Environmental Protection has said in its annual progress report that the government remains largely off track to meet its environmental ambitions and must speed up and scale up its efforts in order to achieve them. The OEP report provides an assessment of government's progress towards legally binding environmental targets and the goals of its environmental improvement plan. It covers the period the 1st of April 22 to the 31st of March 23. And it also includes content on selected cross-cutting themes such as nature-friendly farming and a more in-depth assessment focused on government's apex goal of achieving thriving plants and wildlife. So Dame Glenys Stacey, who's the chair of the OEP, said in relation to the report that it was deeply, deeply concerning that adverse environmental trends continue. She went on, with the depleted state of our natural environment and the unprecedented pace of a climate change, it does seem to many that we are at a crossroads. It is not easy for us as a nation to choose the right path, the right trajectory, and to travel together at the pace needed, but we simply must. Delivery bodies, local government, businesses, and the environment sector need to know in full what part they must play. In our view, government must do more to set out for Parliament, the public, and all those who must play a role in this, how it intends to deliver its ambition. Now, a long-term plan to improve the natural environment in England was first put in place in 2018 with the 25-year environmental plan. Under the Environment Act 2021, this was adopted as the official Environment Improvement Plan, and it was revised in January 2023 as the Environmental Improvement Plan 2023. This report therefore covers the later stages of the original 25-year plan and the early stages of its first revision. It's worth having a look at. Now, continuing with the environmental theme, we now have a date for biodiversity gain, I believe, Dennis.
Indeed. Mandatory Biodiversity Net Gain, or BNG for short, is one of the most significant recent developments in planning law, and the government have announced that it will go live on Monday, the 12th of February. A set of regulations has been made, and local planning authorities and developers alike now need to familiarise themselves with all of these provisions to ensure a seamless implementation of the new procedures. Here's more. From and including the 12th of February 2024, every grant of planning permission under the Town and Country Planning Act 1990 for major development, unless exempt, will be deemed to be granted subject to a general biodiversity net gain condition. The condition cannot be varied or removed. It is set in legislation and deemed to apply, and it will apply to applications for small developments from the 2nd of April. The effect of the condition is to secure that the biodiversity gain objective is met. This means at least a 10% increase in the biodiversity value of the habitat on the land to which the planning permission relates. The condition requires that development may not be begun unless a biodiversity gain plan has been submitted to the planning authority, and the planning authority has approved the plan. Major development will be affected from the 12th of April and includes residential developments with 10 or more dwellings, or other residential development where the site is 0.5 hectares or more and the number of dwellings isn't known. It also includes the provision of buildings, residential or otherwise, where the floor space to be created is 1,000 square meters or more, or any development carried out on a site having an area of 1 hectare or more. Now, BNG for small development will apply from the 2nd of April. Now, those small developments are those that are defined as not being major development. So includes 1 to 9 dwellings or a residential site smaller than 0.5 hectares and buildings with less than 1,000 square meters of floor space, or development carried out on a site having an area of less than 1 hectare. Now, there's a lot more detail on this in Bulletin 4, especially about the transitional arrangements and exemptions that apply. But very briefly, the main exemptions are for development below a certain de minimis threshold, development that does not impact a priority habitat as defined in the regulations, and household development where development to an existing house, but not including a change of use or a change to the number of dwellings. Mandatory BNG represents a big change for planning professionals and for many planning applications made after the 11th of February. Now that we have the final details of the new regime, local planning authorities and developers can invest time and resources in familiarising themselves with it, what they are likely to need to provide by way of BNG, and whether it can be secured in a biodiversity gain plan. Helen.
Now, in other news, and rather unexpected, it's fair to say, it took the sector by surprise, actually, is the government's consultation on the reintroduction of employment tribunal fees. So you'll remember, no doubt, that tribunal fees were introduced in 2013 by the coalition government under a fees order made by then Lord Chancellor Chris Grayling. Straightforward disputes attracted issue and hearing fees totaling £390, while for more complicated matters, the charges totaled £1,200. The Employment Appeal Tribunal attracted total fees of £1,600. The fees were withdrawn in July 2017 after trade union Unison successfully argued before the Supreme Court in our Unison and the Lord Chancellor 2017 that they prevented thousands of employees, particularly people on low incomes, from securing justice. The court held that the fees were unlawful as A, they were in practice unaffordable, and B, they rendered pursuing non-monetary and low value claims, which suffered a greater fall in volumes, futile and irrational, which effectively prevented access to justice. Furthermore, the fee structure was found to be indirectly discriminatory against women and individuals with protected characteristics. The Law Society described the court's ruling at the time as an urgently needed wake-up call, adding that justice must never be a luxury for those who can't afford it. The introduction of fees in 2013 led to a substantial fall in the number of claims brought to the Employment Tribunal. Case volumes fell by 53% in the 12 months after the fee change, from circa 59,000 cases between July 2012 and June 2013 to 28,000 cases between July 2013 and June 2014. Now, the Ministry of Justice claims to have learned lessons from the 2017 judgment. It admits the former charges did not strike the right balance between claimants paying towards tribunal costs and protecting access to justice. The fees proposed within the consultation are admittedly a lot less than those previously set, with a £55 issue fee. The government has said that help with fees would be given to those most in need. The consultation closes on the 25th of March. Now, on that note, you can read more on the items discussed today and many more besides by going to Bulletin number 4 of 2024, available on the LLG website now. So it's goodbye from me.
And from me too.
Have a good week, everyone.